Okay, and Mr. Austin, you've now consulted with your client, and how are we proceeding on this?
Yes, Your Honor. Mr. Carter will be admitting to the violations.
Is that correct, Mr. Carter?
Yes, Your Honor.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Mr. Carter, as I said before, you have the right to a contested hearing. If you plead guilty, you won't have a contested hearing, and you'll be giving up the rights that go along with it. That includes the right to have the allegations proven, the right to have the witnesses against you appear at the hearing and to be able to cross-examine them, the right to have this court order any witnesses that you might have to appear at the hearing, and also the right to testify yourself at the hearing if you wanted to. Do you understand those rights?
Yes, Your Honor.
Has anyone made any promises to get you to plead guilty?
No, ma'am.
Has anyone used any threats or other kind of pressure?
No, Your Honor.
Are you pleading guilty because you believe you did violate probation?
Yes, Your Honor.
Okay, so on this date, August 20, did you fail to report as directed?
Yes, ma'am.
All right, and then August 7, did you drop it at him?
No, I did not, Your Honor.
Okay. The court finds the plea is understandingly, voluntarily, and knowingly made. It is supported by the testimony. The plea of guilty is accepted. Mr. Carter's found guilty of probation violation. Is there a recommendation?
There is, Your Honor. Mr. Carter's been on probation for just over a year now, and this is really his first violations here. It'd be the recommendation of probation that he be continued on probation with 10 days jail, credit for 10 days, and be placed on an MDOC curfew tether for a period of 90 days. I would ask that he be held in custody until I can get that tether on him.
Can you get it on like in 24 hours? Or?
I can do that tomorrow.
Yeah,
yes.
Okay, great, thank you.
Thank you.
Mr. Austin?
Yes, Your Honor. Thank you. Overall, I do find the recommendations to be appropriate. Sounds like Mr. Carter just kind of went through a brief period here where he kind of had a mental lapse, but it sounds like he's realized that and he's getting back on track now. I would ask the court to continue him on probation and not to impose any further upfront incarceration. Thank you.
Thank you. Mr. Carter, anything you would like to say?
Other than I'm really working to get my life back on track, and I appreciate you guys with everything that you guys are doing here for me today, because I could be getting a lot worse of a sentence for this.
Okay, well, you're actually doing quite well. We've had a little glitch here, but you know, I put you on probation over a year ago, and I have not seen you on any violation, so you're doing well. And I want you to, yeah, very, very good. And just step it up, because even little violations can add up and end up with a, you know, like you say, a bigger sentence than this. So
Yes,
you are continued on probation, 10 days in jail with credit for 10 days served, 90 days on MDOC curfew tether. The bench warrant is dismissed. However, you are to be held at the jail until the tether can be placed, which will be within 24 hours, Mr. Carter. So you'll be out soon. You have the right to file an application. You have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for an attorney to go forward with an appeal, you have to make it within 42 days of today's date. It explains that more on a form that we will mail to you. So you are all set, Mr. Carter. Don't forget all your terms, other terms and conditions of probation continue to apply, and but you're all set. So you can tell them at the jail there that you're done with your hearing.
Thank you.
You're welcome. Good luck.
I'm done with my hearing.
Okay. And that takes us to People of the State of Michigan versus Paul Butts, docket number 18-258FH. Mr. Butts?
Yes.
You want to come up to the podium? And then the agent can just stay at the table.
Morning. Good afternoon, John.
Pardon me?
Good afternoon.
Oh, good afternoon. I know, it's difficult. This is People of the State of Michigan versus Paul Butts, docket number 18-258FH. And Mr. Butts, you're here today on allegations that you're in violation of probation. It's alleged here, first of all, that on or about August 9th and August 22nd, you failed to submit to substance abuse testing as directed. And then the other allegation is that on or about August 26th, you failed to make any payments on your court-ordered fees. Do you understand the allegations?
I do.
If they're proven true, it could subject you to a maximum penalty of up to 5 years in prison based on your original conviction. You have the right to be represented by an attorney, and if you can't afford one, one will be appointed for you. And you also have the right to a contested hearing where you could appear by yourself or through an attorney. You could hear the evidence presented against you. You could cross-examine witnesses, and you could present your own evidence. First, are you requesting an attorney?
No,
And second, do you want a contested hearing?
no.
So you're going to plead guilty to this, is
I
that?
am.
Okay, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Mr. Butts, as I said, you have the right to a contested hearing. If you plead guilty, you won't have that, and you'll give up the rights that go along with it. That includes the right to be represented by an attorney, the right to have the allegations proven, the right to have the witnesses against you appear at the hearing and to be able to cross-examine them, the right to have this court order any witnesses that you might have to appear at the hearing, and also the right to testify if you wanted to.
Yes.
You understand those, right?
Yes, I do, Your Honor.
I have a couple of amendments, Your Honor.
Oh.
If there's time for that.
Okay, go ahead.
I'd like to add a few dates to count one that he also failed to drop on September 2nd, September 11th, and September 14th.
Okay,
And I would actually ask the court to dismiss count two. I spoke with Buddy Howes this morning, and apparently there's been two payments made on this matter since I spoke with Mr. Butts previously, one in the amount of $335 and another in the amount of $190.
Can I just say one? I paid on Friday too, I paid it in full, so it is paid in full, the $971.
okay. So the count two is dismissed, strike
Okay,
that.
okay, perfect, thank you.
And then he just added a couple
Okay.
dates to the count one, so. Has anyone made any promises to get you to plead guilty?
No, Your Honor.
Anyone used any threats or other
No.
kinds of pressure?
No, Your Honor.
Are you pleading guilty because you believe you did violate
I
probation?
did.
So now we're just talking about the 5 dates where you failed to submit to substance abuse testing. Did you do that?
I did, Your Honor.
Okay.
The reason being, I've had 5 different probation officers assigned to me in Oakland County. Prior to the one I have now, I had met, and the one, he said, I was doing well, so he said I didn't have to go to the jams anymore, and just to pay this off in full. And then I got this new one, so I did go a couple times, and then I got this new job where I'm working like 12 hours, 13 hours a day. And when I work late at night, it's hard for me to wake up in the morning to call on jams. So that's why I wasn't going. So
Okay.
I did not go, but,
Okay, I hear you. The court finds the plea is understandingly, voluntarily, and knowingly made. It is supported by the testimony. The plea of guilty is accepted. Mr. Butts is found guilty of probation violation. Is there a recommendation?
There's Your Honor. I previously spoke to Mr. Butts on September 1st about these allegations, advising him to show cause. At that time, I told him it was important that he not miss any further drops of jams. I expressed to him at that point if he could make some payments on his fees, I would likely just ask that he be discharged from probation, as he's scheduled to be discharged October 3rd. Since our conversation, he's missed 3 drops. In speaking with the supervising agent in Oakland County, it appears that Mr. Butts just does not take probation very seriously. He's been to TRICAP and House of Commons. He did both successfully complete both programs. He's also been on SCRAM for a period of, I believe, 120 days and successfully completed that. It's troubling that after speaking with him on September 1st and advising him not to miss any more drops, he's missed every single drop at jams he's been ordered since. Therefore, I would ask the court to revoke probation, and I'd leave any additional jail to the discretion of the court. Thank you.
All right, Mr. Butts, anything you would like to say?
no, Your Honor.
Well, I agree, the agent, that it is troubling that you would miss those drops. And, you know, not only after he told you make your drops, but also the reason being that you couldn't get up in time is pretty lame. You know, you're on probation, it's important. But I do disagree with you don't take probation seriously, because I put you on probation 2 years ago, and this is only the second time I've seen you, so,
I do take it seriously, and I have taken it seriously, but I also take my job very seriously too, because it's a very important job to me.
yeah.
It's good money, and I don't know, I don't know.
Well, I'm agreeing with you. I think you do take it seriously because, I haven't seen a whole load of violations out of
And I
you.
haven't.
But I understand wanting, to take your job very seriously too. When you miss that many drops, it makes me wonder what's going on though.
It was just my job.
I hope so.
And it was irritating because it seems like every time I get an appeal, it's like starting all over again with somebody new.
Yeah.
It's been very irritating, and I've been through a lot with this probation, and I've taken it seriously. I just would like to be completed.
I am going to revoke your probation. I just hope the missed drops aren't that you used.
No, not at all, man.
Okay, I'm gonna revoke your probation and, that's it. You have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. This form that he's going to hand to you is the form that you use to do an appeal, and it's the time period of 42 days to do that. It starts running from today.
What does this mean?
I'm sorry?
What does this mean?
You're no longer on probation. I revoked it.
I'm done?
Yeah.
Is that everything?
Yeah.
Thank you, Your Honor.
You're welcome.
All right.
Just stay clean.
Okay, research. I will fix.
All right. Next up is also yours, Agent Forrest, right?
Yes, Your Honor.
This is people of the state of Michigan versus Andrew McClellan. This is people of the state of Michigan versus Andrew McClellan, docket number 17-926FC. Mr. McClellan, you're here today because of allegations that you're in violation of probation. It's alleged here, first of all, that on or about August 26th, you failed to enroll in MRT as directed. And then the other allegation is on or about the same date, you made an untruthful report to the agent. And do you understand the allegations against you?
Yes, Your Honor.
If they're proven true, it could subject you to a maximum penalty of up to 20 years in prison based on your original conviction. You have the right to be represented by an attorney. Looks like Ms. Love is here representing you again.
Good afternoon, Your Honor.
Good afternoon. You also have the right to a contested hearing, or you could appear by yourself or through an attorney. Your attorney, you could hear the evidence presented against you. You could cross-examine witnesses, and you could present your own evidence. And how are we proceeding on this, Ms. Lowe?
He is going to plead to the violations. I have already supplied both Mr. Forrest and Ms. Allen with a copy of the registration confirmation from PATS to show that he now is enrolled in MRT. And then count two, he will also just admit to.
Okay, is that right, Mr. McClellan?
Yes, Your Honor.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Now, as I said, you have the right to a contested hearing. If you plead guilty, you won't have a contested hearing, and you'll be giving up the rights that go along with it. That includes the right to have the allegations proven, the right to have the witnesses against you appear at the hearing and to be able to cross-examine them, the right to have this court order any witnesses that you might have to appear at the hearing, and also the right to testify yourself at the hearing if you wanted to. Do you understand those rights?
Yes, Your Honor.
Has anyone made any promises to get you to plead guilty?
No, Your Honor.
Anyone used any threats or other kinds of pressure?
Not at all.
Are you pleading guilty because you believe you did violate probation?
Yes, Your Honor.
Okay, tell me about it.
On the first count of me not enrolling in MRT,
Uh-huh.
I was just kind of waiting on a grant. I know it's no excuse, but now I have it. I start class on Wednesday, and with
Okay.
me telling Mr. Forrest that I was enrolled in the class, it was because I have contacted him. It was only one time, so that was, bad on my part. I should have contacted him more. I guess I thought I was enrolled in the class, but it occurs that I wasn't, but that's not gonna happen again, just a lack of communication on my part.
The court finds the plea is understandingly, voluntarily, and knowingly made. It is supported by the testimony. The plea of guilty is accepted. Mr. McClellan is found guilty of probation violation. Is there a recommendation?
Sure, Your Honor. Been trying to get Mr. McClellan enrolled into MRT for some time now. While it's unfortunate that it took a show cause being scheduled to do so, nonetheless, it's been done, and I think that that's the primary objective here. So I would just ask that Mr. McClellan be continued on probation, essentially with just a warning for this, and I've reminded him that any future issues with attendance at MRT would likely result in court action. Thank you.
Okay, thank you. And Ms. Love?
I would like you to follow that recommendation.
Okay, Mr. McClellan, anything else you want to say?
Nothing really. I know that I've already enrolled and I've already started reading ahead in the book, and I know I'll be able to get some insight out of the class, so.
Very good. I'm glad to hear that. That's the right thing to say. I hope you mean it.
Oh, I do, trust me, Your Honor.
Okay, because I have seen you a few times on probation.
Yes, this is the second one, yes,
Yeah,
ma'am.
and there've been some administrative sanctions and,
Yeah.
so, you need to take it seriously, and I'm glad to hear that you have that kind of an attitude about the programming and that you're ready to go with it. So that is great. I will continue you on probation, but make sure that you stay with that great attitude. You can't just talk the talk, you gotta walk the walk, you know, so do it. And I'll be very, very happy because you did have a little bit of a bumpy road here. I'll be very happy if I don't see you for a while. I don't mean
Yeah.
anything negative by that. I think you can do this. And
Yeah, me too, Your Honor. You guys
Yeah.
helped out a lot.
Real good, yeah. You've learned a lot?
Yeah, already.
Yeah.
You know, it's been going on 2 years now.
Yeah.
I'm ready to get it finished, that's for sure.
Well, you know, we want you to get it finished, you know?
Yeah, he's a great help. He's there anything I ask him.
We're all on your side. It's just that you gotta do it. So, you know, don't let even minor violations happen because, you know, they add up.
Yes, that's for sure.
Yeah, okay. So you're all set.
All right, thank you. You have a great day.
Thank you.
Thank you. Report date this coming Thursday or next Thursday? Perfect. Thank you.
Mr. Austin, you have Mr. Yates.
Correct.
Do you want to stay there or?
I can do either one, whichever is more convenient.
Mr. Yates?
I don't need an attorney, Your Honor.
Oh, Mr. Yates is in the courtroom. He says he doesn't want an attorney after all.
Okay.
Okay. So this is People of the State of Michigan versus Stephen Yates. Docket number 16-915FH. And Mr. Yates, you are here today on allegations that you're in violation of probation. It's alleged here in count 1 that you were issued a misdemeanor citation for providing false information to the Meridian Township Police Department. In count 2, that you had contact on or about August 15th, excuse me, that's the same date for the first violation too. That you had contact with Chelsea Barker, someone that you're prohibited from having contact with. In count 3, that on or about August 1st, you had drug paraphernalia in your possession. In count 4, on or about August 17, you failed to notify your agent within 24 hours of Meridian Township Police Department contact. And in count 5, on or about August 20th, you provided an untruthful report to probation. Do you understand the allegations?
Yes, Your Honor.
If they're proven true, it could subject you to a maximum penalty of up to 21 years in prison on each of your 2 prior convictions. You have the right to an attorney. If you cannot afford one, one will be appointed for you at public expense. And we have Mr. Austin for you, but you don't want him, is that correct?
Yes, I do.
Okay, you also have the right to a contested hearing, where you could appear by yourself or through an attorney. You could hear the evidence presented against you, you could cross-examine witnesses, and you could present your own evidence. And so how do you want to go forward on this?
I'd like to plead guilty.
Okay, would you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Mr. Yates, as I said, you have the right to a contested hearing. If you plead guilty, you won't have a contested hearing, and you'll be giving up the rights that go along with it. That includes the right to be represented by an attorney, the right to have the allegations proven, the right to have the witnesses against you appear at the hearing and to be able to cross-examine them, the right to have this court order any witnesses that you might have to appear at the hearing, and also the right to testify yourself at the hearing if you wanted to. Do you understand those rights?
Yes, Your Honor.
Has anyone made any promises to get you to plead guilty?
No, Your Honor.
Anyone used any threats or other kinds of pressure?
No, Your Honor.
Are you pleading guilty
Yes, Your Honor.
because you believe you did violate probation?
Yes, Your Honor.
Okay, so did you get a misdemeanor citation for false information to Meridian Township?
Yes, Your Honor.
Have you disposed of that yet, like gone to court on it or anything?
Not yet.
Okay, I will skip that one then. That's dismissed. You're not in violation just for getting a misdemeanor. A violation. But on that same date, August 15th, did you have contact with Chelsea Barker?
Yes, Your Honor.
Okay, and you know I ordered you not to, correct?
Yes, Your Honor.
And then, did you get charged with possession of drug paraphernalia?
No, Your Honor.
No charge?
No charge, no.
Okay, did you have drug paraphernalia?
No, Your Honor. It was actually, to be honest with you, we were doing whippets.
Yep.
And they had a video or a picture of us doing it at the location that I was at.
Yeah.
So
But that's huffing, right?
it's, yeah. Well,
It's using an
a
inhalant?
balloon like nitrous oxide or whatever it is.
Yeah. So you don't consider that drug paraphernalia?
No, I do, Your
No,
Honor.
I don't know. I mean, maybe legally it's not. I don't know.
Yeah, no, it's,
But you were using it like an inhalant, like to get intoxicated?
yes, Your Honor.
Okay. And then did you tell your agent within 24 hours that you had contact with the Meridian Township
No, Your Honor.
police? No? And what happened on August 20th? You made a report and did you what? You
I
lied?
just didn't tell him about
You
it,
didn't
Your
tell
Honor.
him? And he always asks that stuff, right?
Of course, yes.
Yep. The court finds the plea is understandingly, voluntarily, and knowingly made. It is supported by the testimony. The plea of guilty is accepted. Mr. Yates is found guilty of probation violation. Is there a recommendation?
Yes, Your Honor. It looks like the no contact order was added previously when there was some threatening behavior between Mr. Yates and Chelsea Barker. Now in this instance, he's having more contact with her. He's on video using the whippets in Meridian Township. I'd ask that he be continued on probation with 20 days jail and that we refer to outpatient treatment. The unfortunate part in this is that we don't really have any testing available to monitor the whippets. So I think that obviously some outpatient or some sort of treatment would be necessary though. Thank you.
Okay.
I would also ask, I guess, too, that a 3-month extension be added to his probation.
And Mr. Yates, what do you want to say?
All right, well, first of all, let me start with, when we were together, me and Chelsea, it was obviously mutual, and we have a daughter together. I know you ordered me through the court. She has since dropped the video. Everything's been dropped. I believe she is here to speak if you would like her to. As far as the whippets go, Your Honor, I'm not trying to justify anything for what I was doing, but honestly, I look at that as a relapse because I am currently in outpatient at Victory Clinic.
I know, I followed you for a while.
And I haven't, I'm not trying to say, I haven't used any illicit drugs, so I kind of, and to me, I look at it still as a relapse because I did do that,
Yes.
Your Honor. But I'm just trying to tell you the reason why that I did it, and I'm not trying to justify any of that at all. And as far as lying, because that's basically what it was, I was lying, because I didn't tell him the next day. I didn't, report that on our probation. And there's really I was scared because I was with her. That's why I had lied. I didn't want to get violated. I'm not going to try to justify why I did that, but I did do that. And to be honest with you, I think a fair resolution to this, because I've been on probation for, I think, almost 3 years now. I think, I want to, and I'm pretty sure she does too. We want to do family counseling together to work things out, because we have a 2-year-old daughter. I've been going through a lot. Like, I just lost my father a month ago to cancer. I lost my mother at a very young age to cancer. And once again, I'm not trying to ask for sympathy, I'm just telling you what's been going on with me and everything. And I regret using that way. I haven't had no dirty drops. I've been doing really well, and I
have a PV for you a year ago, you used marijuana.
yeah, it's correct, but we did come to court for that, and you did allow the medical marijuana for me.
Yeah, that's.
Afterwards.
Yeah, afterwards.
Yeah, which.
That's not exactly how it works.
Yeah, I understand. I think it's fair. I mean, I know I've been on probation for 3 years, and it's just been so hard. I mean, I got 3 kids with not all the same women, regardless. I never chose my life to come up to this point, obviously, and be in front of you. But I want you to know that I take responsibility. I'd be willing to do X amount of hours of community service. I would love to do the family counseling, and maybe more counseling, individual counseling for myself. So I can, maybe talk about my issues a little more and not lie when something comes up. I should have never lied to him. I like Mr. Forrest, and I honestly felt really bad about it. And as far as, I'm sorry.
No, it's okay. Counseling's a great idea.
And as far as the contact with her, I know you ordered it, and it's a part of my stipulation. We have a 2.5-year-old dog.
I get that, but you know what?
I shouldn't.
This is the second PV for contact with her.
Well, the first one was just ordering that. I've not had 2 violations of it.
I have one for December 18th of 2019, contact with Chelsea.
That was the original when it first got put together. He wasn't my probation officer at the time, it was Mr. Teetsor.
Yeah, I have the police sheet right here. You pled guilty to not making monthly payments, and you went to Chelsea Barker's house.
Like I said, that's when they made the no contact.
Yeah, before that though, that was what your violation was.
Maybe maybe I didn't understand correctly, but yeah, okay.
Because the violation was engaging in assaultive, abusive, threatening, or intimidating behavior towards Chelsea Barker, and then you pled to having contact with Chelsea Barker. But in any event, you said some good things, that you could use some counseling, for sure. You can use all those things. That doesn't mean you walk out of here scot-free for this violation.
Oh, I understand.
No, and I understand the situation with Chelsea, but you have to get past this mindset of do it first and ask permission later. It doesn't work that way. So if you're gonna have contact with Chelsea, go through your agent, and he'll make a recommendation to me about whether that gets removed or not. But I'm gonna consult with him and see what he thinks about it first, and if there's something that needs to be done first for you that would be, make it safer or more appropriate, then we're gonna do that. But you can't just do it. And then this yada yada excuses about, I was relapsing, but I wasn't, because it is and it isn't. No, it's relapsing. It's relapsing. That's what happens when people relapse. They may not use what they used before, but they're going to use something to alter, So let's just call it what it is. You're just not being honest with yourself. I don't care about me. Be honest with yourself, because you're not going to get through this if you can't start by being honest with yourself. You can lie to me from, now to forever. But, the more important thing is that you look yourself in the mirror and say, this is where I'm at, and this is what I'm doing. And you can't fix it if you aren't willing to even do that. You can't fix it. But if you can do that, that's the first step to fixing it. And you can fix it doing that. And you've got support. You've got a good agent to support you. We'll give you what you need, but you've got to do it. And, something simple like don't have contact with someone, you should be able to do that. I understand, substance use disorder is one thing. I mean, people, it's hard to get past that, but don't have contact with someone. Okay, well, she's the mother of my child. I'll guess the right thing is I'll go to my agent and I'll talk to my agent about that. Look, we're trying to work through this. Is there any way I could get that taken off? You don't do that. You just go ahead and have contact with her. And what are you doing with her? Huffing. I mean, come on. I'm going to continue you on probation and sentence you to 20 days in jail. You must complete outpatient substance abuse counseling, and we'll extend the term of your probation 3 months. And you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. That's the appeal period that starts today. It tells more about that on that paper that you're getting right now. And you're remanded to the sheriff.
Okay.